start. These two writ petitions, each filed under Article 32 of the Constitution of India, raise some disputing issues pertaining to the state of Manipur. In writ petition criminal number 129 of 2012, it is stated that over the years, a large number of people, Indian citizens, have been killed by the Manipur police and other security forces while they were in custody or in stage managed encounters or in ways broadly termed as extrajudicial executions. In writ petition civil number 445 of 2012, it is stated that for a very long time the state of Manipur is declared as disturbed areas and is put under the Armed Forces Special Powers Act 1958, subverting the civil rights of citizens of the state and making it possible for the security forces to kill innocent persons with impunity. In this order, we deal with the first writ petition, that is writ petition criminal number 129 2012. In this writ petition, it is stated that during the period May 1979 to May 2012, 1528 people were killed in Manipur in extrajudicial execution. The statement is mainly based on a memorandum prepared by Civil Society Coalition on Human Rights in Manipur and the UN and submitted to one Christoph Hinz, a special rapporteur on extrajudicial summary or arbitrary executions mission to India 19 to 30th March 2012. The memorandum compiles the list of 1528 people allegedly killed unlawfully by the state police or the security forces. The writ petitioners later on filed compilation 1 and compilation 2. In compilation 1, details are given of 10 cases relating to the killings of 11 persons out of the list of 1528. In compilation 2, similarly, details are given of 13 cases in which altogether 17 persons out of the list of 1528 are alleged to have been killed in extrajudicial executions. A counter affidavit is filed on behalf of the state of Manipur. In the counter affidavit, there is not only a complete denial of the allegations in the writ petition, but there also seems to be an attempt to forestall any examination of the matter by this court. The plea is taken that the National Human Rights Commission (NHRC) is the proper authority to monitor the cases referred to in the writ petition. It is stated that in regard to all the 10 cases highlighted in compilation 1 filed by the petitioners, reports have been submitted to it, and in none of those cases the NHRC has recorded any finding of violation of human rights. It is stated that the occasion for this court to examine those cases would arise only if it holds that the NHRC had failed to perform its statutory functions in safeguarding the human rights of the people in the state. This court should not examine this matter directly but should only ask the NHRC to indicate the status of the cases listed and highlighted in the writ petition. We are unable even to follow such a plea. The course suggested by the state will completely dissipate the vigor and vitality of Article 32 of the Constitution. Article 21 coupled with Article 32 of the Constitution provides the finest guarantee and the most effective protection for the most precious of all rights, namely the right to life and personal liberty of every person. Any indication of the violation of the right to life or personal liberty would put all the faculties of this court at high alert to find out the truth, and in case the court finds that there has in fact been violation of the right to life and personal liberty of any person, it would be the court's bounden duty to step in to protect those rights against the unlawful onslaught by the state. We therefore see no reason not to examine the matter directly but only vicariously and second hand through the agency of the NHRC.